Good evening. Good evening, everyone, and welcome. Thank you very much for joining us this evening. My name is Samuel Seymour. I'm president of the New York City Bar, and it's a great pleasure to welcome all of you to this evening's Arps lecture. This is one of our signature events, and one of the really proudest traditions here at the City Bar is to put on a lecture named for Leslie Arps. And I'm particularly proud to welcome our speaker tonight, the Honorable Pierre Leval of the United States Court of Appeals for the Second Circuit. And I'm very pleased to say a longtime active member of the New York City Bar Association, so he's one of ours. As many of you know, this lecture is named for Leslie Arps, a founding partner of the Skadden Arps law firm. It's one of the most important events we do at the association. U.S. Supreme Court Justice Lewis Powell was our inaugural Arps lecturer in 1989, and he's been followed by many distinguished members of the bench and bar. Our most recent Arps lecture was given by Sandra Day O'Connor, and I'm sure tonight will be another wonderful step in that great tradition. We appreciate the support, particularly of the Skadden firm, to make the Arps lecture series such a great success for us. The series addresses issues of important public concern, particularly to the legal community, and Judge Leval's lecture this evening, entitled Distant Genocides, Not a Court's Business, could not be more timely, and is, of course, subject matter is not only relevant to the legal profession, but is a matter of worldwide public concern. Now, at the heart of the lecture series here at the Association is our Arps Committee, which is co-chaired by Scott Musoff and Barry Garfinkel. Barry, a longtime partner of Skadden Arps and a colleague of Leslie Arps, he's going to come up now and tell you a little bit more about Leslie Arps and about our speaker tonight, Judge Leval. So I ask you to join me in welcoming Barry Garfinkel. Barry?
Welcome all. It is indeed my pleasure to introduce the Senior Second Circuit Judge, Pierre Leval. As Sam mentioned, the lecture series was established by Skadden Arps to honor one of the firm's founding partners. There were only three at the time: Les Arps, John Slate, and Marshall Skadden. Previous to their forming the firm, they were associates at the Root Clark firm. Joe Flom was their first associate. This year, we are celebrating our 64th anniversary with 1,800 lawyers worldwide and 24 offices worldwide. At this association, Les was chair of the executive committee, and he served on a number of significant association committees. Now, a word about our speaker, Judge Leval. He was appointed to the Second Circuit in 1993 after having served as a district court judge in the Southern District for 16 years. Judge Leval earned his BA from Harvard College, and in 1963, his degree magna cum laude from Harvard Law School, where he was note editor of the Harvard Law Review. After Harvard, he clerked for the Honorable Henry J. Friendly on the Second Circuit, who David Dawson, in a new biography of Judge Friendly, calls him, quote, the greatest judge of his era, end quote. Judge Leval was then an assistant U.S. attorney in the Southern District, and from 1969 to 1975, he was with the Cleary-Gottlieb firm in New York, where he was a partner, and the Cleary-Gottlieb firm also came from the Root Clark firm, but they started with partners. He then joined Bob Morgenthau in the New York County DA's office, serving first as the first assistant district attorney and then as chief assistant district attorney. And Bob Morgenthau is with us tonight. Welcome, Bob. Following his work in the DA's office, he was appointed in 1977 to the Southern District Bench. On the circuit court for nearly 20 years, Judge Leval has been a class act. I want to share with you some of the comments about him as published in the Almanac of the Federal Judiciary. Lawyers uniformly rave about Judge Leval's legal skills. One commented, quote, "He is a great judge in every way," end quote. Another, quote, "He is one of the great Second Circuit judges," end quote. Now, I can go on until the reception, reiterating the splendid comments about him. Judge Leval is an adjunct professor at New York University School of Law. In 1997, he received the Federal Bar Association's coveted Learned Hand Medal. He also has received honorary doctorates from the Vermont Law School and New York Law School. The list of lectures he has given at notable institutions, frankly, is awesome. Permit me to mention a few. He delivered the James Madison Lecture at NYU School of Law, the Horace Manges Lecture on Intellectual Property at Columbia, the Fowler Harper Fellowship Lecture at Yale, and at Hofstra Law, the Alexander Bickel Distinguished Professor Lectureship on Communications. A final note about Judge Leval's dedication and hard work as an assistant U.S. attorney. Bob Morgenthau has reported that when Judge Leval was an assistant, on one occasion he fell asleep at his desk and rolled off his chair onto the floor, where a cleaning lady found him the next morning, sound asleep on the floor. I'm confident that the judge's presentation to you tonight will not put any of you to sleep. After the judge's presentation, we will have a cocktail reception at the Great Hall for all. So thank you, and I give you Judge Leval.
I can fall asleep just about anywhere. I'm deeply honored to be invited to deliver the Leslie Arps Memorial Lecture. I never met Les Arps, but we had a kinship of trial by fire, in that as young lawyers, we both worked for the very, very great, but not easily pleased Henry Friendly. By all that I've heard, Les Arps was an extraordinary lawyer, a very distinguished public servant as well, a mensch, and what an achievement to have been one of the founders of the great Skadden Arps firm. I'm very grateful, Barry, for this extraordinary honor and for your excessively gracious fabrications in introducing me. I'm going to speak to you on two subjects. The first does not exist. The second exists, but it's about to disappear. This may be the most useless talk of all time. Perhaps I should pause briefly to allow everyone to leave. Apparently, no one here has anything important to do. Both subjects concern a civil action, that is, a private suit by which a plaintiff seeks redress for atrocities in violation of the law of nations, atrocities committed in another nation where the plaintiff cannot get justice. Now, let me be clear. By a private civil suit, I mean a suit by which the plaintiff seeks only a private civil remedy, such as compensation, but does not seek imprisonment, fine, or any kind of criminal punishment. Outside the United States, there is no such thing as the kind of suit I have described. In the United States, such an action has existed, at least in theory, since the birth of the nation, and has flourished for the last 30 years, but will likely be banished in the next term of the Supreme Court, in part because the other nations of the world don't provide such a suit. So why do I waste your time on something so unimportant? Well, I hope you will join me in the belief that it is not unimportant. Where it doesn't exist, it should exist, and where it does exist, it should remain. The human rights situation in the world today is dismal. It's better, no doubt, than it was 200 years ago, but it's still dismal. In our lifetimes, we have seen, and we continue to see, genocides and mutilation, sometimes coupled with systematic rape. Think Cambodia, Rwanda, Serbia, Iraq, Sierra Leone, numerous others. Arbitrary imprisonment and torture of political opponents of the government in many, many, many nations. Massive disappearances, preceded, of course, by torture and murder in Perón's Argentina and Pinochet's Chile. And today, a scourge of alarming proportions, consisting of brutal enslavement of countless children and young women in sex trade, apparently rampant in Eastern Europe, India, and many Asian nations. There are reports of traffickers swooping down on places of natural calamity, earthquakes, tsunamis, and places like that, to kidnap orphaned children into sex traffic. Because all of this is done in hiding, it's impossible to estimate the number of victims, but it's believed to be vast, possibly in the millions. Because all of this, excuse me, such trafficking is almost always done with police protection, obtained, of course, by bribe payments. Thus, local government officials participate in the huge profits of sex slavery. Ordinarily, either because of the status of the abusers of these kinds of offenses or because the acts were part of the government's policy, such acts are not redressable or even in many cases unlawful under the local laws of the nation where they occur. So what is the legal status of such atrocities? It has been clear since Nuremberg that regardless of legality under local law, such atrocities violate what is called the law of nations and is thus illegal, regardless where it occurred. The law of nations recognized what is called jus cogens, mandatory law by the consensus of nations. The jus cogens prohibits a small core of particularly heinous abuses that are viewed in the community of nations as so incompatible with civilization as to render the abuser hostis humani generis, that is, the enemy of all mankind. And the abuses include genocide, slavery, official torture. The predominance of the law of nations over local law is crucial to the concept. The conduct of Hitler's Gestapo was not illegal under the laws of the Third Reich. It was nonetheless illegal under the law of nations and thus subject to prosecution at Nuremberg. Another important feature of the law of nations is the notion of universal jurisdiction. Because such atrocious offenses can rarely be challenged where they are committed, the law of nations provides for universal jurisdiction. The offenses may be prosecuted anywhere in the world. By treaty, many nations have created international tribunals. Those tribunals are by and large established at The Hague in the Netherlands, but they try offenses committed in many places elsewhere in the world. The precise meaning of universal jurisdiction is not always clear. Under some views of universal jurisdiction, the presence of the defendant before the court is a prerequisite, as before the international tribunals. On other views, the defendant need have no connection whatsoever to the tribunal. In a recent case in the Netherlands, decided under universal jurisdiction but not under the law of nations, Libyan defendants were held liable for tortures committed in a Libyan prison where the defendants had no apparent connection to the Netherlands forum. In some countries, a foreign defendant may be sued in tort if the plaintiff is a national of the forum state. Now, in spite of all this highfalutin talk, the law of nations is more theoretical than real. Criminal prosecution in the international tribunals is rare, slow, and inefficient. In the 10 years of its existence, the International Criminal Court has had only 10 cases either tried or on their way to trial, and only one conviction. There was one great success in this area just a couple of weeks ago in the Special Court for Sierra Leone, where they had the conviction of the Liberian dictator Charles Taylor for his role in unspeakable horrors, including giving countless children in Sierra Leone smiles and short sleeves, which meant cutting off their lips and their hands. The trial, however, of Charles Taylor took nearly 5 years. The conviction of a single man, notwithstanding his prominence in the world of rogues, hardly makes a dent. Criminal prosecution in the courts of other nations is virtually non-existent. There was, of course, one very famous successful example, the trial of Eichmann in Israel. We have right now, and for a long time, ineffectual efforts to bring about another one in that Belgium, for years, has been unsuccessfully seeking the extradition from Senegal of the barbaric former dictator of Chad, Hissène Habré, to face criminal prosecution. But it looks like it will be a long wait if it ever happens. With very rare exceptions established under treaty, no suit can be brought against the offending nation. It is protected by sovereign immunity. And as I said, no nation outside the United States offers a civil suit. It is true the International Criminal Court has the power to award compensation as redress, but it never has done so. That may be in part because conviction is a prerequisite, and until 2 months ago, the court had never had a conviction. It's perhaps also in part because seeking damages would divert the court from its principal mission. So to be sure that we're on the same page and you understand exactly the kind of case I'm talking about, I'm going to propose a hypothetical case, a hypothetical set of facts. So let's assume nation X, let's call it despotamia, an abusive dictatorship in which political protest results in imprisonment, torture, disappearance, perhaps summary execution. Genocide is practiced against disfavored tribes or racial groups. Children of the disfavored tribes or races are kidnapped and sold into sex slavery. The defendant in our suit is the chief of police, a cousin of the despot president, and throughout his career, the defendant, as chief of police, has supervised these abuses. The defendant lives in luxury, regularly vacations in his magnificent villa in the forum state, which is, we can say, any one of the law-respecting nations of the world: Chile, South Africa, France, India, any nation. So while the defendant is in the forum state, he is sued by the plaintiff in the forum state's courts. And the plaintiff alleges as follows. The complaint says, when I was a 6-year-old child in a tribal village in Despotamia, the defendant supervised a genocidal rampage against my tribe that killed my parents, cut off my right hand, kidnapped me and sold me into sex slavery. For 10 years, my captors kept me imprisoned in a brothel, selling the privilege of raping me 30, 40 times a day. I was beaten if I didn't please the customers. The defendant gave the traffickers police protection in return for a share of the profits. Once I escaped, the police, under the defendant's command, captured me and returned me to the brothel, for which the defendant received extra pay. No remedy can be had in Despotamia, where the despot's regime continues, and my demand is for the profits the defendant earned from my exploitation, as well as for my pain and suffering. Do you think that I'm being over-dramatic and loading the dice in my hypothetical? The sad fact is that this describes significant portions of the real world which we are fortunate enough not to see. What is the result of the suit? Suit dismissed. Our courts don't hear suits for foreign atrocities, notwithstanding that the suit cannot be maintained anywhere in the world. Nowhere in the world outside the United States can such a suit be heard. Is that right? Is that law? Is that how we think the world should be? So what are reasons why a forum state ought to allow such a suit? Some of them seem pretty obvious. If these are the worst offenses known to mankind and are illegal under the law of nations, aren't they deserving of relief? A civil suit offers compensation of the victim, a measure of solace, the satisfaction of confrontation. Still more important, such a suit offers worldwide exposure of atrocities of this nature. And such exposure helps inch by inch to improve the conduct of governments. Even the cruelest of despots, oddly enough, seem to be adverse to being exposed to the world as monsters. The forum state, by allowing such a suit, would align itself with the protection of human rights rather than passively enabling abuses. And the absence of any remedy for such atrocities makes the law of nations something of a toothless joke. What are the obstacles to the maintenance of such a suit? In code nations, which means most nations, courts act only with statutory authorization, and at present, no such statutory authorization exists for the exercise of universal jurisdiction for such foreign atrocities. Furthermore, the practice rules of most nations would present huge obstacles to such actions being brought. For example, in most countries, a plaintiff must post bond for the defendant's attorney's fees before starting the case, and contingency arrangements are prohibited for the representation of plaintiffs. The absence of discovery, furthermore, would make it very difficult to prove these cases. Now, the lack of statutory authorization does not necessarily represent the national policy of all of those potential forum states not to allow such an action. The fact may simply be that the issue has never been put in a forceful way to the legislature. The laws that I mentioned concerning counsel fees and discovery, they do represent policy, a policy to protect the nation's defendants, the nation's potential defendants, against frivolous litigation. Nonetheless, perhaps law-respecting nations could be persuaded to make limited exceptions from those rules for cases of the sort I'm talking about. Why? Well, in the first place, these cases involve foreign defendants, not those for whom the protection is designed. Allegedly, at least, they involve the world's worst offenses, offenses that scream out for vindication. And as protection of the policy against the facilitation of frivolous litigation, the statute could require a prior demonstration of substance. So why might law-respecting nations nonetheless reject such rule changes that might allow such actions to be brought? This is largely guesswork. There have been a few attempts to cause such laws to be adopted. There's no record of failed attempts or reasons that are visible. The literature suggests some possible reasons that are given. None seem to me in any way to justify the prohibition. Some have no merit whatsoever. Some have merit, but only as to certain cases, and generally speaking, a small number of cases. One view is that violations of the law of nations are matters for state-to-state confrontation. They are not suitable for private litigation. Well, that is a view that's rooted in the 18th or 19th century, because the law of nations at that time was limited to issues involving state-to-state relations. The law of nations concerned such subjects as national boundaries, sovereign immunity, safe conduct for ambassadors, and also piracy, which was a matter of great concern to all nations because of the importance of trade among nations. This view completely ignores the huge change in the law, in the nature of the law of nations that occurred at Nuremberg. At Nuremberg, in worldwide horror at the Nazi program, the law of nations was expanded to encompass a state's infliction of atrocities on its own nationals. The view that the law of nations should be vindicated only in state-to-state confrontation is completely incompatible with the modern law of nations. Another concept that might be offered in opposition is that such atrocities should be vindicated only by hearing them in the criminal system. Atrocities of this magnitude, it is said, can be trivialized by hearing them in a civil suit. Now, that's a very odd and, to me, totally illogical view. It means that minor bad conduct obtains relief, but the world's most atrocious abuses do not. It makes no sense whatsoever. One view that's offered is that there's no need for a civil remedy. This is because criminal proceedings can be initiated upon the complaint of a private individual, and criminal proceedings can carry provision for compensatory remedy. This is not a good reason to reject suits of this sort. A criminal proceeding is, by definition, an affair of state. A private individual, of course, can request the prosecution by making a complaint, but the prosecution must be by a state officer. States are often unwilling to prosecute, perhaps for diplomatic reasons, or perhaps simply because the local prosecutor has his own priorities and needs. And it's not altogether clear why a local prosecutor would advance his career by prosecuting or pursuing officials of another nation. Prosecutors of international tribunals also have their own priorities and their shortages of resources. Their motivation is to get convictions. Seeking damages for victims would hugely complicate their task with little benefit for them. So the view that compensation of victims should come in criminal prosecutions, not civil actions, means effectively that there will be no compensatory remedy available in the world for victims. Another view is that the forum state court's entertainment of suits of this nature can harm the foreign policy of the government of the forum state vis-a-vis the offending nation. Now, that is absolutely true. There's no doubt that it can harm the foreign policy of the government vis-a-vis the offending nation. But in those cases, the government can ask or direct the court to abstain, and the court should abstain in those cases. In many cases, however, the government has no objection whatsoever to the prosecution of such a suit. Indeed, in many cases, the government would favor adjudication. The legitimate concern for the forum state's conduct of foreign relations can be entirely accommodated by abstention in the cases to which that concern applies, rather than in all cases. A related concern has to do with programs of reconciliation and amnesty. Sometimes the maintenance of a civil suit like that can interfere with a program of reconciliation at the place of the wrong. Once again, it's true, but that applies to only a tiny number of cases and could be administered for those cases as opposed to stopping justice in all cases. Finally, a very big obstacle is the notion that distant genocides are simply not our worry and not the business of our courts. This, I submit, is wrong both as a matter of law and as a matter of policy. First, with respect to law, it is commonplace for courts of general jurisdiction to adjudicate disputes in tort or in contract, disputes that arose in another nation, even when that dispute is governed by foreign law, the law of the nation where it arose. It's wrong also as a matter of policy. Atrocities in violation of the law of nations are every nation's business, especially in the circumstances when the victim cannot get justice elsewhere in the world. That was the lesson of Nuremberg. So what is to be done? Those who believe that the cause of human rights would be valuably served by such actions should not passively accept the status quo. Organizations interested in advancing human rights should not lose courage, but should seek foreign advocacy partners, with them institute publicity campaigns and lobby legislatures and government of law-respecting nations, and they should draft proposed model legislation to authorize and facilitate such actions. The drafting of a model bill, it should be of modest scope and should, of course, be designed to meet anticipated opposition. Pushback can be expected from the government, especially the Foreign Office. This is because of the worry that suits will cause diplomatic difficulties. To calm the worries of the Foreign Office, perhaps the model statute should require, as a prerequisite to suit, prior notification of the Foreign Office of intent to sue and no objection by the Foreign Office, or perhaps even should require an affirmative written statement of no objection by the Foreign Office. As in the United States, perhaps it should require some contact of the defendant with the forum state before exercising universal jurisdiction, at least when the plaintiff is not a national or bona fide resident of the forum state. The authorization of jurisdiction should perhaps depend on a showing that not only that the plaintiff cannot get justice in the place of the wrong, but perhaps also require a showing of probable cause. To disarm an expected source of powerful opposition, legislation might be wise and might do well to exempt corporate defendants from coverage. The bill should require dismissal under the doctrine of forum nonconveniens whenever access to the courts is available in another nation that is better suited in some way to hear the case. Now, I'm not so naive as to believe that such lobbying efforts will rapidly succeed, or perhaps ever succeed, or that many plaintiffs will succeed in collecting on their judgments if they are fortunate enough to win judgments. But if we value the international law of human rights, it is surely worth an unflagging effort. I come now to the very different situation in the United States of America. Since the birth of this nation, we have had a statute of the sort that I'm speaking about, the Alien Tort Statute. I will call it the ATS. It was passed by the first Congress in 1789. The ATS authorizes the federal courts to hear suits brought by aliens for torts in violation of the law of nations. Since a 1795 opinion of the Attorney General, it has been recognized as authorizing federal court jurisdiction of an alien suit for violation of the law of nations which was committed in a foreign land. And since the case of Filartiga v. Pena in my circuit in 1980, federal courts have heard cases, not large in number, in which aliens pleaded torts in violation of the law of nations, nearly always in a foreign land. For reasons that I am at a loss to understand, this line of cases has provoked hostility of stunning intensity among the far-right wing of U.S. legal thought. A recent piece of scholarship describes this as the most contested issue in the U.S. foreign relations law during the last decade. In 2004, the Supreme Court decided the case of Sosa versus Alvarez. The court, by a majority of 6 justices, generally upheld the validity of a federal court's adjudication of an alien claim of tort in violation of the law of nations committed in another nation. The court, however, dismissed the particular suit because it found that the tort alleged, arbitrary arrest unauthorized by local law, was not among the extreme heinous offenses prohibited by the law of nations. The part of the majority opinion that expressed general approval of suits under the ATS was fiercely attacked in a minority opinion written by Justice Scalia, speaking also for Chief Justice Rehnquist and Justice Thomas. The minority opinion would have done away with all suits under the ATS. It is remarkable for its thunderbolts of anger. Of the court majority, for example, the opinion scoffs, "This court seems incapable of admitting that some matters, any matters, are none of its business." Notwithstanding the intensity of the contempt the minority opinion expressed for those who disagreed, its arguments seem to me extraordinarily contrived and weak. First, the opinion posits that the act passed by the first Congress had no function or effect whatsoever. It constituted nothing more than a grant of jurisdiction to hear claims that didn't exist and would not exist unless someday further laws might be passed that would authorize such claims. To say the least, that's a curious piece of statutory interpretation. Second, the opinion argued that the federal courts could not recognize a claim under the law of nations because Justice Brandeis's famous ruling in Erie v. Tompkins stripped the federal courts of general common law powers. The argument that Erie deprived federal courts of power to recognize the law of nations through federal common law overreads and misinterprets Erie. The question in Erie was whether federal courts had any authority to prefer their own common law to the common law developed by state courts in determining what is the state's law. The case simply did not involve whether federal courts possess common law powers in areas of law that are entrusted to them as opposed to state law questions. Notwithstanding some broad language, the case did not deny federal courts such power. Indeed, federal courts have always made law by the common law method in areas not governed by state law or by a federal statute, and they continue to do so. Those areas have included matters of maritime law and international law, such as sovereign immunity and the law of nations. Now, on the other hand, a worry that underlay the minority justices to resort to such improbable arguments is not frivolous. The minority opinion contemplated what it described as the appalling proposition that the American people's democratic adoption of the death penalty could be judicially nullified because of the disapproving views of foreigners. The law of nations, of course, does not reject the death penalty, but there are some in the world who think it should, and as illustrated at Nuremberg, the law of nations is subject to change. So let me examine briefly the problem of potential conflict between the law of nations and the law of the United States. I cannot disagree that uncomfortable and difficult problems would arise if and when federal judges confronted a case in which actions expressly authorized by federal or state law came to be violations of a new changed standard of the law of nations. The problem is interesting, at least in theory, although unlikely ever to ripen into anything real. The minority justices in Sosa worried most about losing the death penalty. Other observers might worry more about other potential conflicts. Think of a possible conflict involving, for example, the right of free speech. Suppose that the nations of the world, in a universal fit of brotherly love, were to espouse the principle that hate speech is incompatible with civilization and violates the law of nations. Such a law of nations rule would, of course, conflict with our First Amendment. What then? Would the law of nations prohibition of hate speech trump our right of free speech? How would a federal court rule in a suit against a state official alleging hate speech? It's hard for me to imagine that a U.S. court might rule that such an official acted illegally in exercising the constitutional right of free speech. However, a conflict between the law of nations and the law of the United States can occur otherwise than through change in the law of nations. It can occur through change in the law of the United States. How to resolve such a conflict may seem less obvious in those circumstances. Suppose, for example, that U.S. law came to authorize atrocities which we had long accepted as violations of the law of nations. Improbable? Sure. Not necessarily any more improbable than that the law of nations would come to forbid the death penalty, which remains very widely practiced in the world. But suppose that Congress or the President, acting in either case within constitutionally assigned powers, were to delegate to an inferior officer the free discretion to hold prisoners in a condition of slavery or to inflict torture, how would a federal court best answer a suit alleging violation of the law of nations brought by one of the victims of presidentially or statutorily authorized torture? The answer comes less easily. Now, scholars Curtis Bradley and Jack Goldsmith, who have written extensively on the ATS, deal with the problem of potential conflict with federal law in an extremely interesting manner, which simply avoids adjudication of such a case by a federal court. They focus on Article 3, Section 2 of the Constitution. That section places limits on the jurisdiction of the United States courts. Article 3 lists several categories of cases that are authorized to be heard by federal courts. The only category that can accommodate the ATS case is, quote, cases arising under the laws of the United States. And that works only if the law of nations is deemed to be the law of the United States. Because the law of nations applies in the United States, as it does the world over, there is a basis for the court to find that it is part of the law of the United States. But can the same be true if Congress has enacted a law that conflicts with the law of nations? How can both be the law of the United States? In the eyes of an international tribunal, the law of nations would take precedence over contrary local law. Thus, the Nuremberg Tribunal found violations of the law of nations regardless of the fact that the Nazi atrocities were authorized by the law of the Third Reich. But it does not follow that a U.S. court may find a law of nations rule that is contrary to U.S. statute is nonetheless the law of the United States. Bradley and Goldsmith observe that all legislative powers are vested by the Constitution in Congress within the limits of its authority, and the Constitution gives the President sole authority within specified areas, such as the conduct of war. Because of the exclusive authority of Congress and the President within their areas of power, a U.S. judge lacks authority to find that the law of nations is otherwise than as established by Congress or the President. The federal court, on their view, would be compelled to dismiss that suit on the ground that it does not come within the jurisdiction authorized by Article 3. The court would make no ruling one way or the other on the merits of the case. Dismissal would, of course, be a favorable result for the defendant, especially in a world where no other court would entertain a similar suit. But the ruling would not represent a finding that the defendant did not violate the law of nations or the plaintiff's rights. It would not mean that in the case of conflict between local law and the law of nations, that local law prevails. A domestic tribunal of another nation, if it heard such suits, could impose liability on the U.S. official for violation of the law of nations. And so could an international treaty court if the U.S. was a member of the treaty. No nation can immunize its officials from a finding of liability under the law of nations simply by passing laws either authorizing its intended atrocities or by granting broad powers to the head of state. But a nation can determine what are its own laws, even if they conflict with the law of nations, and can also determine the scope of its own court's authority. Now, in response to the minority justices of Sosa, 2 points. How exactly to describe the relationship between the law of nations and local law of any nation is a complicated question upon which scholars disagree. The possibility that federal law might someday conflict with the law of nations is not a valid reason to nullify the ATS. In case of a conflict with federal law, the federal courts would lack jurisdiction to hear the case. For a conflict between the law of nations and state law, the answers are less clear and more open to dispute. But even if the court would have jurisdiction of a case involving a conflict, those troubling hypothetical questions are not raised by the characteristic ATS action, such as my hypothetical case from Despotamia, In such a case, a victim seeks compensation for violation of well-established norms of international law, which have been recognized with U.S. approval for over a half a century. The possibility of such a conflict is improbable and far-fetched. In no respect do our laws conflict with the law of nations, and they probably never will. This is not a coincidence. It is because the United States is a civilized nation, and the law of nations is premised on the concepts of civilization that prevail in the United States and other civilized, law-respecting nations. A couple of months ago, the Supreme Court heard argument in an ATS case from our circuit. The question upon which review had been granted was quite a narrow question: whether the law of nations imposes liability on corporations and other artificial entities. However, views expressed by the justices at the argument and the Supreme Court's action shortly after the argument have cast doubt on whether the ATS will survive in any form for atrocities committed in other nations. Justice Kennedy asked at the argument, "No other nation in the world permits its court to exercise universal jurisdiction over extraterritorial human rights abuses to which the nation had no connection. Are you saying that that proposition is irrelevant?" Chief Justice Roberts asked, "If there's no other country where their suit could have been brought, isn't it a legitimate concern that allowing the suit itself contravenes international law?" Justice Alito, noting that the facts involve no connection to the United States, asked, "What business does a case like that have in the courts of the United States?" And following the argument, the Supreme Court put the case over for re-argument in the next term on a much broader question: whether the ATS allows courts to recognize a cause of action for violations of the law of nations occurring within the territory of a sovereign other than the United States. In other words, are genocides in another land any proper business of our courts? Will the Supreme Court shut down the ATS as to atrocities in other nations? I have come to and past the seventh inning of my talk, and perhaps the ATS is long past the seventh inning of its existence. So I'm going to rest my voice for a short minute and invite you to stand up and take a seventh inning stretch, and I will come to the conclusion of my talk. So, two issues are now before the Supreme Court. First, whether the law of nations exempts corporations. Second, whether the ATS applies to violations of the law of nations that occurred in other nations. As for the liability of corporations under the law of nations, I will not discuss the merits of that question. I have taken the position in a published opinion that the law of nations does apply to corporations. But I suspect that regardless of the correct answer to that question, the law of nations, the Alien Tort Statute, and the protection of human rights might be better off on balance if the Supreme Court were to rule that corporations are not covered. Why is that? First, huge multinational corporations operating primarily through trade groups have amassed an influential campaign to kill the ATS, or failing that, restrict it as far as possible. Corporations that operate in nations with bad human rights records have been magnets for ATS suits. They have been preferred targets, in large part because the prime abusers, usually the officials of a despotic government, are not present in the United States and cannot be sued here. Those suits generally ascribe to the corporate defendant a secondary role of aider and abetter in the local government's atrocities. Rarely is it contended that business companies are the prime movers in the alleged atrocities. A Supreme Court ruling that corporations are immune under the law of nations would end the powerful campaign by the world's mightiest economic powers to cripple or kill the ATS. It seems to me that the cause of human rights would be the net winner, even at the loss of some deserving cases, if that were the Supreme Court's ruling. I move to the issue of extraterritoriality. It appears that the court is preparing to rule that the ATS does not authorize suits for atrocities committed in foreign lands. Such a ruling, of course, would slam shut what is, as a practical matter, the world's only open door to a remedy for victims of mankind's most heinous abuses. Some believe that the Supreme Court's recent ruling in Morrison against National Australian Bank commands such a result. Morrison should have no bearing on the question whatsoever. It addresses a very different problem. The issue in Morrison was the extraterritorial application of a U.S. regulatory statute. The court ruled that unless a contrary intent appears, such regulation is understood to apply only within the territorial jurisdiction of the United States. It's difficult to find fault with that principle. When Congress regulates, presumably it regulates for the United States and not for the entire world. A federal court's finding of violation of the law of nations that occurred in a foreign nation is a very different question. This does not involve imposing U.S. regulatory law on other nations. To the contrary, it involves the enforcement of regulatory law created by the collectivity of nations with the intent that it apply throughout the world. The fact that other nations have not authorized their courts to hear similar suits is not a reason for the Supreme Court to strip the ATS of extraterritorial jurisdiction under the principle of universal jurisdiction. The community of nations has espoused universal jurisdiction as integral, indeed essential, to the law of nations. The heinous offenses that comprise the law of nations are offenses against the entire world. And because other nations will not police their own violations, the law of nations without universal jurisdiction would be nothing more than a pious fraud. While it is true that the international courts established by treaty may adjudicate only as to nations joining in the treaty, the precedent of Nuremberg made clear that the law of nations applies and is enforceable whether a nation consents or does not consent. I conclude with a few questions. Are distant genocides the proper business of a court? Very much so, when the victim cannot obtain relief in the place of the offense. Can suits for foreign atrocities interfere with the foreign nation's foreign policy? Yes, but that threat can be avoided by the simple mechanism of the foreign nation's government advising the court that it should not entertain that particular case. This easily avoided potential for interference in a few cases is no reason to reject the cause of justice in all cases. Should such suits be entertained if there's a more suitable forum in another nation? No. Courts should make liberal use of forum nonconvenience dismissal when the suit would more justly be heard in another nation. Does the failure of other nations to exercise universal jurisdiction over abuses for fundamental human rights justify a cessation of the United States courts doing so. What should rather happen is that the other nations of the world should shed their timid reluctance and shoulder a part of the burden of the law of nations. We recognized at Nuremberg, in the words of Justice Robert H. Jackson, Chief Counsel of the United States, that we are dealing with wrongs, I quote, so calculated, so malignant, and so devastating that civilization cannot tolerate their being ignored because it cannot survive their being repeated. It would be a sad retreat from Justice Jackson's noble and ambitious objectives if the Supreme Court were to rule that distant genocides are not the proper business of our courts. Thank you very much.
Judge Leval, thank you for a stimulating and brilliant address. Now we're going to adjourn, have a reception out in the Great Hall, and please join all and Judge Leval by coming. Thank you again for coming. Yeah, that was really terrific.
Thank you so much.
I mean, that's really fabulous. I do want to send it along.